The information provided in this podcast is prepared by Ocean Estate Law PC for informational purposes only and does not constitute legal advice. The information is not intended to create an attorney-client relationship. It is not legal advice or a substitute for obtaining legal advice from an attorney. A person listening or watching should not rely upon it in any manner without engaging professional counsel. The information is intended to communicate general information and, because recorded, may not be current.
Welcome to the Ocean Estate Law Podcast. Thanks for joining us today, where we talk about all things estate planning. I am attorney Jennifer Elliott. I own San Clemente Estate Law and Laguna Estate Law, all under the umbrella of Ocean Estate Law. This podcast is to educate our listeners about estate planning, and we will also be bringing experts on to help us avoid taxes, stay out of court, and really help you protect your family better. So I'm a certified specialist in trust, estate, and probate law by the State Bar of California. I've been practicing for 20 years, and I am happy that you're here with us today. Please continue to join us over the coming podcasts where we cover several areas related to estate planning. Today, I would like to introduce Jill Griffith. Jill Griffith is with Clarity Group Financial. She is a CPA. She's been a CPA for over 20 years. She's right here in Aliso Viejo, California. And I am so thankful that you're here today, Jill. Thank you for being with us on the Ocean Estate Law Podcast.
Well, thank you for having me. It's a great honor to be here with you.
So Jill and I, we have been referring cases back to each other for several years. Mm-hmm. And you have also been so responsive when I call you with questions. My clients have come to rely on your expertise. And
well, thank you.
Yeah. Sure. Thank you for continuing to take care of my clients. So I wanted to talk about some crossovers with estate planning law and your work as a CPA, so we can help educate people about when they need us,
right.
when they don't. Like, are there some things that they can get by with doing themselves? And what our value is, what we can do to save the money.
Right. And that is really something that both of our teams can help save people money. I mean, they just don't realize it because they're trying to do things on their own, which is just not a great idea.
No, sometimes that's a really bad idea.
Really bad idea.
We're going to outline some of those things today. First, I'd like to start with just estate planning. So I'm counseling people about estate planning. We're drafting their basic documents, their will, their trusts, their powers of attorney, their healthcare directives. And oftentimes when I'm counseling them, things come up like, how can I avoid paying taxes? And how can I get some money out of my estate? And one of the great strategies is to do that with making gifts.
Correct.
Now, there was just a change in the gift tax law. Can you tell us about it?
Well, the gift tax goes up every year. Well, not every year. Okay, let me take that back. It does go up. So an individual can give away $17,000 to another individual and not even tell the IRS about it. It's just one of those things you can do. You can, if you're a husband and wife team, you can give with two sons, you can actually give away $17,000 to each son, and your wife can give $17,000 to each son. And if they're married, you can give the wife $17,000, both wives $17,000. So reality is you can save, over $100,000 in just gifting dollars away in a gift. It's $17,000 for 2023. That does change. So, we go with the current year. And so that is a lot of money that you can just get out of your estate and give it to your children. You don't need to pass away. You don't need to wait until you pass away to give those dollars. Just start gifting now.
Right. So can someone just write a check to their kids and their family, the grandkids and everybody, for over $100,000?
Well, no, you can, but you do need to report that then. So this limit of $17,000 is the unreportable section that you do not have to file an actual tax return, a gift tax return for, a 709. You cannot do that. But if you do, let's say, $100,000 instead of $17,000 to one individual in 1 year, then you are going to need to file that gift tax return. Is that something that you don't want to think about? If you just come to see us, we can plan it out, a strategy to get that $100,000 to that individual in other ways.
Sure. So a gift tax return is reporting it to the IRS. It's going to cost a client an extra fee for you to do the 709 gift tax return, right?
That is true. But they will save a lot more in the long run if they do it, with some guidance, right? So that is really what we're trying to do, is save them and keep them compliant. I mean, another thing is you do need to be compliant with the IRS rules. So we do try and keep everybody compliant and above board. And so there's no mystery or no surprises when you should pass away and you do need to file either a 706 or an estate return, whatever the case may be.
Sure. So if a client comes and sees you, you'd be able to help them with the right strategy, the planning to make sure that they're only gifting $17,000 per person per year, no extra gift tax return necessary.
Right, and that's a simple one. Now, there's obviously larger strategies you can have for gifting, but that's just, something that, just as individuals, us everyday people, was something we want to do, give our children gifts.
Sure.
Get that money out of the estate.
So what if a client says, I want to gift my son a piece of real estate?
Well, you can, but we would recommend not doing that.
Yeah. So
there are other strategies when it comes to trusts and tax planning for when somebody is going to pass away to do it in other ways. So we would definitely recommend your firm for this.
Yeah. So we're going to be talking about that later in the show today, about how there is a better way to handle that.
Yes.
Yeah.
There barely is.
So you were talking about the 709 gift tax return. So say someone does have to report the gift tax, and that means the IRS is keeping track of those gifts that exceed the $17,000 per person per year, and that counts against them at the end of their life.
It does.
And that's the lifetime exemption.
Right. So if you are filing gift tax returns, you have right now for 2023, it is $12.92 million. So if you passed, you have $12.92 million. That's not included in you're not going to be paying tax on that, right? That's, less than the threshold. The reality is they are going to pick up all those assets and everything from when they pass away. So that $12.92 million can come up pretty darn quickly, especially when in California and you have a business, you have a property tax, you have a rental. I mean, not a property tax, but you have a rental, you have your home, you have a second home. All of these different items can go over $12.92 million pretty darn quickly. Sure. I mean, so people are surprised, but they don't want to be. So that's why we try and do strategies so they don't go over that, right? We're not paying tax. You have trust strategies in place. You have tax saving strategies in place. And so we like to keep it down below that if we possibly can. Not everybody's going to do that. Most of us will be under that. But reality is there are some people that they need those higher end strategies.
Sure. And so if they are above $12.92 million over their lifetime, they get hit with a pretty big estate tax, 40%.
It's huge. It's huge. You don't want to go that high.
No. So that's why it's important to do the proper gift tax, so you can get some of that money out of your estate and we can keep you under the 12.92. There's some other strategies, but that's exactly why you need a CPA and a estate lawyer.
Right. Yes, you do. You need to talk about these strategies with them. Right. Yes. And there's multiple strategies.
Sure. Now, I would say, this is an estimate, about 99% of us are under 12.92 million. I certainly am.
Me too. Wish I wasn't, but I am.
But there's a law change coming, and a lot more people are going to be over the the lifetime exemption because it's going to be dropping.
Right. So now it's going to go down to probably, in 2026. So at the end of 2025, it reverts back down to, it's a 5 million, but then it gets indexed. So we're thinking around 6 million, it's going to be about that. But a lot more people are going to fall into that category, a lot. So just think about it in California, a couple of homes, a home, some stocks, you could be over it pretty darn quickly.
Sure.
And we have to think about that. I mean, it just goes quick. So these are definitely things you want to take into consideration now.
Right. So if someone is watching and they think, oh, I've got well under 12.92 million, I don't need to worry about estate planning. Or I know that when the law changes on 1/1/26, I've still got less than 5 million plus inflation, so less than 6 million. I still don't worry about estate planning. And I tell them, you've got to worry about estate planning if you want to keep out of probate court, if you want to keep in control of your assets and not let the state of California decide who's going to raise your minor children, who's going to get what
There's
asset.
a lot to think about there. I mean, you really need to do, and if you have property, I mean, let's just say you have a house, you don't want that to go to probate. An average $1 million house in California, how much is that in probate costs? I can't even imagine.
Yeah, typical probate is about $50,000.
Yes.
That is a cost, so that's $50,000 that never gets passed on to your loved ones.
Right, and it may even get passed on to other people that you didn't want to have that.
It could, yeah.
Yeah. So you really want to have a trust set up in place.
Right.
Mhm.
So far we've been talking about a family that is doing some estate planning, trying to get monies out of their estate so they're living, they're alive and well. So that's estate planning.
Mhm.
And then I want to switch gears a little bit and talk about trust administration. So trust administration is one of the parties has passed. So if we use an example of husband and wife are married, we call them Mr. and Mrs. Jones, not their real names, but Mr. and Mrs. Jones for
That
our
will work,
example.
yeah.
And Mr. Jones has passed away, and we're going to pick on Mr. Jones because statistically husbands die first.
Yes, that is absolutely true. Good thing we're women here.
Good thing, yes.
We're going to live a little longer.
So in our example, Mr. Jones is going to die first.
Yes.
Okay, and then we'll say that the husband dies in 2023.
Okay.
And what I'm getting at is capital gains. This is a huge benefit that people have when they come and use their CPAs and their estate planners because we can avoid capital gains tax.
Right. There is one strategy for you can avoid capital gains, yes. And we are a community property here in California. So a community property state, if you have assets that were jointly, taken into consideration in a community property state, you can get away with zero tax.
Right.
Yeah. So if you have a home that, let's say in 1995, it was for $300,000, they purchased it.
Okay, so let's go to the whiteboard and give an example. So we'll say that Mr. and Mrs. Jones, they buy a house in 1995,
Right.
and they immediately put that house into a revocable trust
Okay.
in 1995.
All
Okay,
right.
so purchase price of the house, $300,000 in 1995. That is the basis, right?
Correct. That is.
And then Mr. Jones dies in this year, 2023, and their property is in Orange County. Tons of appreciation. So we're going to say that their house is now worth $1.3 million.
Wow. Yeah, that's true.
So for easy math, there's a gain of $1 million. Now, if Mrs. Jones does not come and talk to her CPA, does not come and talk to her estate planner, and she decides this house is too big and I've lost my spouse and I am just not comfortable staying in this house, especially when my grandchildren live in Northern California.
Mm-hmm.
So I want to sell this property and I want to go live near my grandkids in Palo Alto. So she sells the property. If she doesn't have the right counsel, let's talk about capital gains. So say she uses her $250,000 exemption because this is her residence. Now there is a $750,000 gain. And the IRS is saying, hey, Mrs. Jones, you did a really great job of appreciating your property there. We want our cut of that.
Right.
And so what would you say would be a reasonable rate for capital gains tax?
Well, 20% for federal, 20% at this.
Yeah.
Mm-hmm.
So 20% for federal, that is taxes of $150,000.
And don't forget the state is going to pop in there and get some too. They want their dollars.
What is the state of California going to be asking for?
Probably about 10%. That's just an average, 10%.
So another 10% to the state of California, $225,000 in capital gains tax.
Exactly. And they could have avoided that. Okay, if they had gotten an appraisal right off the top, because the fact is you get a step up in basis when one of the spouses die. And 1.3 million, if they had gotten an appraisal and they had talked to us about this, could save them tons of tax. And they don't think about it that way. No, they don't even think, it doesn't go into they have no idea, one, that they get a step up in basis on the death of one of the spouses. And so it never comes into play, and they overpay their taxes to Uncle Sam. And that's coming right out of their the money that they really want to go to their children when they pass away.
Sure. So step up in basis. This is a term that I use with clients, and sometimes their eyes look like they roll back in their head because it sounds like a really big, scary tax term.
Yes.
And so I want to break it down and make it not scary so people understand.
Well, one of the things that's scary is basically what it is. The step up in basis is you're just wiping out the cost, original cost. You just don't even think about it anymore. And now you just, that appraisal value is what the property is worth. Okay, you just wipe out the old and start with the new. And that's kind of something that's easy. People think about that a little bit more instead of step up in basis. You're right. Those are technical terms that people just don't understand.
Right. So if we're looking at the basis on the whiteboard, so we've got $300,000 used to be the basis for when they purchase a property.
Mm-hmm.
And then Mr. Jones has died in 2023. And the step up in basis means that the $300,000 goes up to the $1.3 million.
Mm-hmm.
And
there's no tax.
There's no tax.
No tax.
So if Mrs. Jones doesn't just go and sell her house and move to Palo Alto,
Mm-hmm.
she comes and she sees Jill and Jennifer together, we can take this $225,000.
Make it go away.
Yeah. Definitely important to come and see us or another estate planner, another CPA.
They need to talk to somebody before they do different transactions. And unfortunately, the people are grieving, so they're not thinking sometimes, oh, I need to go immediately out and see someone. But there is a little bit of a window of time before, they decide to really sell. So there's time to get, and they need to be talking to you.
Sure. Now, sometimes people are really afraid of dealing with taxes and dealing with law.
Mm-hmm.
Some people think we're scary.
Yes, I don't know where they get that.
I know, we're really fun, right?
We are. We're easy to get along with. No, I don't know where they get that. No, they are. And I think it's intimidating because they don't know what they don't know. And so sometimes they're intimidated because they don't know what questions to ask. And that's why we're here to guide them. We guide them through the process. And I think we're really good at that. So taking into consideration everybody's individual needs, what they need, how we can help them. Is it, did both spouses pass away? And then, what happens then, and then, how do the trustees or the administrators handle the estate? And do they need an EIN number and all that good stuff?
Sure. Yeah, we're going to be talking about those things today too. So I want to ask you, what if it's not real estate that Mrs. Jones sells? Are there other issues in step up in basis, other assets?
Yes, all the assets can be stepped up in basis. Like, let's say stocks. They have stocks. That is not, now the stocks cannot be in a retirement plan. So let's just bypass retirement plans. That's another issue. But if you have stocks in a mutual account with you are both on there, you can get that step up in basis also. So there's something to think about. And a lot of brokers are not good about recognizing it and doing it for them. They would have to know that fact and then tell their brokers. And that's a shame.
Sure. Now, a few minutes ago, we were talking about what if Mrs. Jones just gives a gift of this property? What if she doesn't sell it? She just gifts it to one of her kids.
That's probably a bad idea.
Yeah, a bad idea because a gift during lifetime that exceeds $17,000 per person per year.
Yeah. Well, it's going to go in a gift tax return, but that's not necessarily the bad part about it. But that son doesn't get the step up in basis.
Right.
And so that son is going to be paying tax on it. And that wasn't really probably their intent, but they don't realize that. They're thinking, oh, I just in case something happens to me, I'm going to give it to my son. But reality is there's going to be tax consequences with that. So there's other ways to do that.
Yeah. So losing that step up in basis means
they're going to be paying $225,000.
Right.
They're going to be paying tax on that, which it's huge. And that's a lot of money that they don't think about.
Sure. Now, this is our example, and some people might be watching this and going, oh, well, Jill just said that my tax bill is going to be $225,000. I want to stop and make sure that people go and see their CPA and see their estate planner so they are talking about their specific facts.
Right.
We don't want them to rely on these numbers because these are just examples, and they've really got to talk about their own property, their figures, their family, their own tax situation.
Right. Exactly. Everybody's different. You can't rely on your neighbor for advice because they have a different situation and different scenario. You need to go see and talk about your scenario and your individual items that need to be coming up. And that's a lot. It is. It can be a lot, but you need to discuss it.
Sure. So we're not telling you rely on these figures. We're telling you go see the professional.
Right.
Give us a call the CPA or estate planner
Right.
in your town so you can get specific advice that you can rely on.
Yeah, that's going to be for you.
Sure.
Mm-hmm.
Okay, so we've been talking about the situation where Mr. Jones passed away, and now I want to throw in another snag. Now Mrs. Jones has passed away. So this is trust administration in which both of the settlors have now passed, and now a successor trustee steps in and handles the estate for them.
Right.
And sometimes people think, I am the successor trustee. All I have to do is just pass out the checks like the trust told me, and that's all, right? I don't really need a CPA. I don't really need an estate planner.
Yeah, that's not good. They are most of them are grieving, and that's not a great time to make the decisions on your own. You need to talk to somebody that's a professional that can help guide you through this. There's a lot of steps. Trust becomes its own entity when you pass away. Somebody passes away. So the administrator is administrating an entity, not individuals at that point in time. While the individuals need their final tax returns completed, the estate, usually administrator, takes care of that. It's just not them anymore. It's a trust. The trust becomes alive, and at that point in time, you have to follow the trust documents.
Right.
And it needs its own EIN number. It doesn't follow the Social Security numbers anymore. It has its own. It becomes living at that point.
Sure. So a successor trustee should not be filing the tax returns based on Mr. and Mrs. Jones' Social Security number.
Right.
Right.
Yeah. Yes.
What about obtaining that EIN? I tell people you need a CPA or an estate attorney to obtain the EIN for you, because I once had a client that said, oh, this is pretty simple. I'm just going to go ahead and get this EIN on my own. Do you know where I'm going with this?
And then
we see this. So they ask you a series of questions. And if you get those questions wrong, you could cause some really serious harm that takes a long time to undo. So in this particular client that I'm thinking of, he reported, instead of reporting mom and dad's passing, he reported himself as deceased.
Yes.
And I'm laughing, but it wasn't funny for him because it took us about 6 months to undo that. So the idea where he said, I'm going to save some money. I'm not going to hire an attorney or a CPA to do this. And it ended up costing him way more than it would have if he had one of us do it, because we had to call the call the IRS and undo that and make him living again.
Right. Yeah, the IRS has made it easy, except for the fact that you have to know what you're doing, else you don't. It's not easy. And so for us as professionals, we do this all the time. We receive EIN numbers for businesses along with trust and everything else. So we are very familiar with the terminology and what to expect. Somebody coming in is not recommended. Absolutely not. I would say no, don't do it yourself. You're just going to get yourself into trouble. You're going to check a box that you weren't supposed to check, and who knows what you did. Either kill yourself off or I don't know, but yes, not a great idea.
Now, what if successor trustee decides, I am going to file these trust tax returns myself. I don't really need a CPA. I file my own taxes. Why can't I file the trust taxes?
Yeah, I know. I mean, people get overwhelmed on it, and it's not something they want to do themselves. They are complicated. They can be complicated. You have to make sure you have all your information, and they don't understand the difference usually between a trust and a corpus, and so that really makes a difference when you're filing a tax return, especially a trust tax return. That's what it's all about. So you really need to know, and you really need to know exactly what the trust says so you can follow the instrument in regards to reporting the tax returns correctly. And that is something without any kind of knowledge you don't want to do.
Sure. When I'm talking with people who are the successor trustee, it is very commonly a child of the couple that passes away and has been named as a successor trustee. Or maybe it's a person that's just a close friend or trusted advisor. But the successor trustee says, the beneficiaries are hounding me. They wanted their money like yesterday because they've already got a vacation planned, a kitchen remodel plan. They want their money now. Why can't I just go ahead and give them their money now? Why do I need to do the administration with you, Jennifer? Why do I need to have a CPA handle this? And I tell them it is the probate code. And so it is this book here that I pull out for them. And
Oh, wow.
yeah, this is my
like a
outdated
tax
version.
code.
I've got the current version in my office. I know, this is huge.
It is.
So this controls, and this document in the 16,000 section talks about trust law. And there is a section in here that says the trustee has a duty to avoid conflicts. So it becomes a conflict if he prepares a tax return himself and he's also acting as a trustee.
Yes, it does make a difference, right? You don't want to do that. You want to keep it separate. Unfortunately, in our litigious society nowadays, if one of the beneficiaries is not happy, they are going to go in and obtain a lawyer of their own, and they're going to ask for an accounting. And if you get to that point, it's always good to have a third party, an outside third party that's doing that for you and helping you with that. And so you don't have to worry about this other individual that may not be happy with the way things are divided.
Right. And that's when I refer them to you, Jill, because if they see that someone else is preparing the accounting and it's not just the trustee has collected all the assets and they're trying to, figure out the accounting themselves, they don't really feel that level of transparency. But when they have a CPA that is involved and showing them, okay, here's what money we started with, these are the expenses, this is what money is left, then it does so much to keep families out of court.
Yes.
Because they feel like, okay, we've got professionals that are handling this, and I know that I can trust a CPA. Maybe my brother is, I kind of doubt his bookkeeping skills, or he just went to Vegas and,
what did he do with that money?
Right, where's that money?
Yeah.
But if you've got a CPA that is handling everything for you, that really,
it makes a difference.
It does.
It's a comfort level for everyone. And then as administrator and trustee, they're doing their due diligence. They're making sure that they're keeping up with their fiduciary duties, and that's great.
Right. One of those fiduciary duties is to keep the beneficiaries informed.
Yes.
And so having us on board with helping to let the trustee know you have a duty to inform the beneficiaries, that does so much to keep them out of probate court. That's a whole thing that they're trying to do in estate planning is I want to keep my family out of court. I don't want my kids fighting.
Right.
I want them to get along after I pass away. And so that's where we really add value in.
Yes, to keep them out of court is really, really important. You don't want to see the siblings fighting and then all of a sudden, everybody's at each other's throats. That's not the way to do it. And the parents would not want that.
True. So I really appreciate how quickly you jump in when I call you with a question. The clients that I've referred to you have always been so pleased in getting the answers that they need to their tax questions. They'll call and tell me she's not scary. Like I got real answers, and it was so helpful for calming their nerves.
Yes.
You can see when clients walk in and they feel like all this weight, like, oh, what is she going to tell me? My tax bill is going to be huge. I'm so nervous. And then
yes. Yeah, you know what? It's just walking them through, and everybody has a different knowledge level. So everybody's starting a little bit different. And so what we try and do is find out what their knowledge level is and then walk them through the steps from there. Because some people have no idea. They are just nothing. They have no idea what the first even step is. What do I need to do? EIN, why? What's the next step? I have to have a bank account with things. And so we just walk them through. What do you have? What does the estate have? What did your parents have? Let's walk through this, look at the trust. Let's go through that. And then if we have any questions at all, we always go back to the attorney that prepares it, because they can clarify what the verbiage is or what was really, meant by this paragraph or something like that. That's always the good point. So
Right.
we always work together in regards to things like that.
We do work well together. That's a favorite part of my job, is telling clients, I got this. I know how to do this. I've got experts that I can reach out to that have done this for 20 years. You're in good hands. And they leave the office just like relieved.
Right, they do. Yes, and it is nice to see that, because you're like, okay, I got that. Okay, I got this. They feel like they can handle it.
Right.
Yes.
Jill, thank you so much for your time today.
No problem. Thank you for inviting me. I appreciate it.
Sure, I will continue to refer clients to you, and
And same here.
thank you. So Jill is an expert CPA in tax, and I am happy to recommend her services to you. Jill Griffith, thank you so much for being here on the Ocean Estate Law Podcast.
Oh, thank you for having me. I appreciate it. It was fun.
Thank you for joining us. This podcast is meant to educate you, help you save money on taxes, help you be aware of what the estate tax laws are like, and I am happy to bring on experts that can help give more information. Please contact us if you have further questions. You can reach me at San Clemente Estate Law and Laguna Estate Law. We're all part of the Ocean Estate Law brand. Thanks for joining us for this episode of the Ocean Estate Law Podcast. We look forward to future episodes where we educate you about tax law, estate planning law, and keep your family out of court.
Any accounting, business, or tax advice contained in this podcast, including attachments and enclosures, is not intended as a thorough, in-depth analysis of specific issues, nor a substitute for a formal opinion, nor is it sufficient to avoid tax-related penalties. If desired, Clarity Financial Group would be pleased to perform the requisite search and provide you with a detailed written analysis. Such an engagement may be the subject of a separate engagement letter that would define the scope and limits of the desired consultation services.